Depends on the person. Some people are good at it, some people are not very good at describing vehicles and their models and years and so on.
Mr. Baldwin.
No, thank you, Judge.
Mr. McClelland.
No questions, Judge. Thank you.
Thank you, Mr. Mullen. You may step down.
Thank you.
You may call your next witness.
Call Tobe Leazenby.
Witness sworn.
Thank you, Judge. Good afternoon.
Good afternoon.
Would you state and spell your name for the jury, please?
It's Tobe Leazenby, Leazenby, as in zebra, E-N-B-Y.
Some people may not know the spelling of Tobe. Would you do that, as?
I'm sorry, T-O-B.
Okay. Thank you. What is your job title?
I serve as the Carroll County Chief Deputy under Sheriff Liggett with a major's title.
Okay. And what, prior, did you do?
Prior to being Chief Deputy, I was the elected Sheriff of Carroll County, serving from 2015 to 2022.
So were you then the sheriff in February of 2017?
I was.
Okay. And I don't want to get into a whole lot, you're here for just a very short period of time, but just tell the jury kind of how you got involved in the investigation, what did you do in the investigation, and so forth.
In my capacity at that time period, as I indicated, I was sheriff, and so a lot of my duties were administrative, and so I did not play a huge role with the investigation. I was not, if you will, boots on the ground, but rather, was kept up to date by our investigators at that time period.
Okay. So you were involved in at least the knowledge of what was going on?
Yes.
Okay. So I want to just kind of cut to it, it's been a long day. Based upon your knowledge of the investigation and who you talked to and what you know about it, how many individuals do you think were involved in this crime?
The initial information was unknown as far as, obviously, we were starting.
Okay. How many people did you think, even after Mr. Allen was arrested, were involved in the crime?
At that point, I only felt one.
Okay. Do you remember taking a deposition with me on August, I think it was the 5th of 2023?
Vaguely, yes.
And you swore to tell the truth, the whole truth, and nothing but the truth at that time?
Yes.
Okay. Would it help me to refresh your recollection about how many people you thought were involved in the crime in August of 2023, by looking at your deposition?
Yes.
Thank you. And I don't have the paper copy, I have it on computer here. I'm gonna have you look at page 19, lines 19 through 25.
Okay.
If you when you're done, let me know if that refreshes your recollection.
Mr. Baldwin, do you have a hard copy?
I don't.
Okay. That's fine. I'll try to.
I'm sorry.
Judge, if I could have a moment to pull it up.
And going to the next page, I don't know if I call you former Sheriff Leazenby or...
Tobe's fine.
I'll bring it over to you.
That's okay, I've got it. What are the page numbers, please?
There's 19, kind of middle of the page to the end, and then 20.
I can't seem to get it to scroll up, almost there. Okay.
Does that help refresh your recollection about how many people who told me you felt were involved in the murders when you were deposed in August of 2023?
Yes, that information does.
Okay. And how many people did you think were involved in the murders of Abby and Libby as of August of 2023?
That information was multiple or at least 2.
Okay. And Richard Allen was arrested in October of 2022, correct?
Yes.
And that deposition took place about 10 months later?
Yes.
And you felt, 10 months after his arrest, that at least 2 people were involved?
Judge, objection. It's been asked and answered.
That's fine.
Sustained.
I just wanted to, okay. And you weren't the only. Were there anyone else that believed that more than one person was involved?
Judge, I'm gonna object. It calls for speculation.
Sustained.
How many others, if you know, believed that more than one person was involved in the crime, the murders of Abby and Libby?
Judge, same objection.
If he knows.
I do not.
Do you know of anyone, at least one person?
No one comes to mind.
Okay. Would it help to refresh your recollection if you looked at your deposition again?
Yes.
Okay. I'm going to ask you to refresh your recollection by looking at, you can use your finger on this one.
Okay.
Page 103, lines 10 through 25, and then the next page, which is page 104.
Okay.
That's page 103 it's on right now.
Okay. Okay.
Does that help refresh your recollection as to who else believed that you?
Yes.
And who was that?
Judge, may I ask some foundational questions?
You may.
Mr. Leazenby, were you aware, when you made the deposition, of the feelings of other officers involved in the investigation? Let me rephrase that. Did you know what other officers believed, other officers that had been involved in the investigation? Did you know what they believed at the time you gave the deposition?
A lot of what I provided.
Just did you know?
No.
What other officers believed?
No.
At the time you gave the deposition?
Not at the time of the depositions, no.
At the time you gave the deposition, were you aware, or let me back up, let me strike that. At the time of the deposition, well, I'll just stop there, Judge. I don't have any other foundational questions. Same objection, it calls for speculation, and so the state's gonna object to the question, Judge.
Overruled.
Thank you, Judge. Go ahead and answer the question.
Could you rephrase that, please?
Sure. Who was it, now that your recollection has been refreshed, that believed that there was more than one person involved in the murder of Abby and Libby?
At that time, then Detective Tony Liggett.
Okay. And why did you believe that more than one person was involved?
That was based on early conversation in the investigation.
Okay. Well, this deposition was taken in August of 2023, and you didn't give any, you didn't say that then, you just, did you? You just said, yeah, I think that it's more than one person, right?
I did then, yes.
Okay. So at that time, and you've been, well, strike that. In August of 2023, when the deposition was taken, how long had you been involved in the investigation or the knowledge of the investigation of the murders at that time?
At least over, yeah.
5 years.
Affirmative response.
So with all that knowledge that you had in your brain when you took that deposition, you still thought more than one person was involved in the murders, is that correct?
Based on an early conversation.
Early, okay. Early meaning 2017. Yes.
Yes.
Okay. So you did not have any other conversations about the investigation from 2017 until 2023?
No, there were ongoing conversation as the investigation progressed through the years.
Okay.
But not necessarily on the number of individuals involved.
So that was not talked about, the number of individuals involved.
It was mainly focused on the tips and information that were continually coming in.
I appreciate that. And I don't think you ever answered my question. No matter what it was based on, why did you think, based upon your knowledge of the investigation, that more than one person was involved in the murders of Abby and Libby?
It was based upon the totality as the word I'll use of the information provided to investigators during that time period, so it was the bigger picture in knowing what had actually happened at the crime scene.
Okay. Thank you. I don't have any other questions.
Mr. McClelland.
You testified before that you weren't thievery involved in the investigation. Is that correct?
Correct.
And so did you know all? Is it fair to say you did not know all the details?
Correct.
I don't have any other questions, Judge.
Mr. Baldwin.
You were the sheriff in 2017.
Yes.
And 2018.
Yes.
And 2019.
Yes.
And 2020.
All the way through 2022.
No other questions.
Mr. McClelland.
No, Judge.
Does anybody on the jury have any questions for Major Leazenby?
Sidebar conference conducted.
How many murders have you personally investigated in your career?
That's good.
Okay.
Sidebar conference concluded.
Major, how many murders have you personally investigated in your career?
I've not personally investigated murders, although I've been involved, being a smaller agency, with other homicides within this county.
Any follow-up, Mr. Baldwin?
No, Judge. Thank you.
Mr. McClelland?
No, Your Honor.
All right. Thank you, sir. You may step down. Okay. Well, ladies and gentlemen, that's the last witness for the day, so we will call it a day. While you go on about your business then the rest of the afternoon, and into the evening, please, remember what I've told you about not talking about the case amongst yourself, or with anyone else, since you will be under the supervision of the bailiffs. Have a safe and a peaceful evening, and we'll see you all in the morning. Gentlemen.
All rise.
Jury out at 5:01 p.m.
You may be seated. So we have a couple of things we need to resolve before we recess for the day. I know the defendant filed motions for transport orders for DOC inmates. There's a pending motion for witness to appear remotely, and the defendant's motion to admit evidence of Odinism, Norse paganism, and ritualistic killings, two of those. So can we address I know that the defendant filed its motion for transport of DOC. The most recent one that you filed that you indicated you really wanted was inmate Jesse James, so I have granted that one, and have signed that one as of yesterday.
Thank you, Judge. Just to maybe make this quick, there were several other that were filed a few weeks ago.
Yes.
And at this time, I'm communicating with Mr. Goodwin, the Attorney General that's representing the DOC.
Okay.
And I don't think that we really need you to sign any of those orders right now.
Okay.
We're trying to avoid bringing as many of those people as we can.
Okay.
But I may be revisiting one or two of those early next week, depending on how the evidence shapes up over the next couple of days.
Okay. So do you need that one gentleman?
Well, I would like to maintain that order.
Okay.
Again, the order says that, upon 24 hours notice to the DOC, they'll bring him. So it's not like he has to be here. I think that's the
Yes.
way you craft them.
Okay.
So there's some flexibility.
So that one's done.
Thank you for that.
So you can let me know about that one.
I will.
Then at a later time, whenever you want to do that. Okay. The motion for the witness to appear remotely. Your Honor, we received discovery in mid-August that brought some new issues, such as Mr. Weber, his whereabouts on February 13th, his vehicle. We have been investigating that, tracking that down since, and working with the U.S. Attorney's Office and the FBI and their attorneys in how to address this and Mr. Weber's prior inconsistent statements. We had hoping to resolve this issue through Officer Goatee's testimony, and I had been working with the attorneys who were here earlier about that. Obviously, we were not able to do so. The problem is that Supervisory Special Agent Pohl is the special or is the in command of, basically, election security in Texas, and I am told he is unable to be here Monday through Wednesday. While these proceedings were happening today, another issue arose with him that he is unable. He has a medical issue which I believe prevents him from flying. Mr. Rozzi was able to talk to the other judge in Carroll County. A Zoom platform is available. That judge is willing to come in tomorrow to facilitate that. Administrative Rule 14(c) says a court must conduct all testimonial proceedings in person except the court may conduct a proceeding remotely for all or some of the case participants, case for good cause shown or by agreement of the parties. Your Honor, I do not believe Special Agent Pohl's testimony is going to be probably not more than a half hour. We had been working with the U.S. Attorney's Office pursuant to a TUI request for quite some time, whether he would have to appear in person or remotely, and given the short time of his testimony that we believe it'll take, his medical issues, his job duties in Texas, we believe that there's good cause show for him to testify remotely. Furthermore, he can't given his medical condition. As a layperson with some knowledge of this condition, I'm not even sure he could drive here. And so Agent Pohl's testimony has a tendency to rebut Mr. Weber's claim that he drove straight home, and we believe that Mr. Allen's Sixth Amendment right is also at play here, Fifth and Sixth Amendment rights also at play here, as good cause to allow him to appear remotely. When was he sent a subpoena? Maybe 3 or 4 weeks ago. But there's an additional process involving TUI requests. I'm familiar with the TUI requests. Sure. And so we've been talking back and forth with the U.S. Attorney's Office about how to accomplish this since then.
You had the evidence in August and issued a subpoena 2 or 3 weeks ago. I just want to get the time frame correct.
Sure. Yeah, it was before the trial, in I believe early October.
You sent a subpoena in early October for this trial?
Yes.
To start on October 14th?
Yes. But we didn't have all of, the information about what was going to be discussed was kind of an ongoing. We weren't sure what we would need to do that. And it's not that, Your Honor, they're not fighting the subpone A, it's just whether he can appear in person, because he can't, with his medication condition. That just came to light today. Otherwise, they would have been able to get him here.
And the state's position? You are objecting.
Judge, I'm objecting to him being called as a witness for this impeachment purpose, and I noted that on the record, and I respect the court's decision that you've overruled that objection. So that's the state's objection. I'd leave whether or not he appears remotely to the discretion of the court. I think the better way to impeach Weber is through Mr. Weber, and that hasn't been done. And again, I understand the court has made their decision. And so that's the state's objection, that he is allowed to testify as an impeachment witness to Weber altogether. I'd leave the part about whether or not he can appear remotely to the discretion of the court.
Well, again, this witness, Weber, was never confronted with the statement, correct? By Agent Pohl.
It is my belief that he was, Judge, and that's what we talked about on the sidebar, but I believe that did happen.
And my recollection, Judge, is that he started to read the statement to him. I didn't think it was proper impeachment, and that's the state's stance, Judge, and that's why we're objecting to the witness, not necessarily whether or not he can appear telephonically.
Your Honor, the state also presented evidence that he went directly home, and so this is also rebuttal evidence that he did not.
Judge, I disagree with rebuttal. I think he's solely being called to impeach the testimony that Brad Weber gave.
My memory, Judge, is that I asked Mr. Weber, did you tell Agent Pohl and Agent Goatee that you went and, that didn't go directly home, you worked on your ATM machines? He said, no, he got all mad, and that's when it ended. That's my memory of it.
That's my recollection too, and that's improper impeachment. He didn't give him an opportunity to review the document and say, Do you recall this document? And then follow up with the questions. So that's my recollection, as well.
And I did review my notes, and that's not how it you never showed him the report.
Well, I'm sorry, Judge, in my opinion, once he denies that, I think it's improper to show somebody a third party, that's typically their own deposition. I don't know that you can show them another report of somebody else, that's just my way of thinking, but...
Well, he was never confronted with the statement, that's the point.
It's an inconsistent.
That's the impeachment.
I'm sorry, Judge, to interrupt.
No, but I mean, the point of impeachment is to say it, and he was never confronted with that specific statement.
That is a form of impeachment. There's also where somebody says on the stand, I said A, and then they didn't say A, and somebody comes up and says, no, they didn't say A, they said B, and that's what this is. This is, he said on the stand, I never said that, and Pole, again, would get upon the stand and say he did say that, so that, it's just a different, in my experience, at least, that's a different thing. You can call that impeachment or you can call it an inconsistent statement that's being offered not for the truth, to prove the truth of the matter asserted, but to show that there was a statement made that is inconsistent.
Well, I understand that there is the technology to appear remotely for this witness. I don't think I've heard good cause shown based on the issuance of the subpoena, so I'm gonna deny the motion. The last thing then is your motion, Mr. Baldwin.
Judge, to make it simple, I would just stand on the motion itself, both of them.
So no additional argument.
No additional.
Mr. McClelland.
Judge, if I understand the motions, the defense is claiming that we've opened the door by the questions that we had, and I hope I can cover all of these issues in here, but I believe, in part, it was from the testimony of Kaur, and perhaps Olehi, and then Holman. I don't believe the state has opened the door at this point. Specifically to Olehi, they initiated, and with Holman, they initiated those questions. Any questions after that were just follow-up questions to clarify the questions from the defense. And so the state does not believe they've opened the door at this point to allow those that third-party motive or third-party evidence into this trial, Judge.
Anything else?
Yes, Judge. Certainly, Judge, when the state puts in evidence of sticks on these girls in what I would label in a very unusual way, especially on Abby, that invites questioning from the defense of the witnesses, so I would say they opened the door is the way I would. It would be ineffective assistance of counsel for me not to ask questions about that and, therefore, I asked questions about that. It's not door opening, it's, it's cross-examination based upon what they put into evidence, so I would say that. Then there's the whole situation involving the undoing, that was definitely not offered by the state, by the defense, that was offered by the state of Indiana on redirect by Mr. McClelland, who asked was it also thought that the reasons for the sticks on the bodies was an undoing G, and the answer was yes and not, so we have a different opinion. It is not an undoing, it is from Odinism, it is from Norse paganism, we have an expert that has testified to that. And certainly, the state has invited opening the door through that questioning and that should allow us to put in our own reasons why we think those sticks were on the girls and how they were formed and so forth, and that's a Sixth Amendment right that Mr. Allen has. And then, I'll just let the other argument stand, Judge, as it relates to, Mr. Lieutenant Holman saying that only one person was involved, because more than one person, then it's gonna leak out, because more people can't, basically there's just more opportunity for that information to leak out about the crimes and, certainly, through the Franks memo, through the testimony from August 1st, we have learned that Elvis Field said that, ask the question, if my spit is found on the girls, but I have an explanation for it, would I still be in trouble? I would call that an incriminating type of comment or question. And then, we have the linkage between Elvis Fields and Brad Holder, therefore, what Lieutenant Holman said on the stand bears itself out to be true, that more than one person, in our belief, are involved in the crime. Elvis Fields made an incriminating statement. We believe there's strong, evidence that a guy 125 miles away in Rushville and a guy up in Logansport who are following each other and mimicking each other on Facebook, that is an inexplicable connection, that the common denominator is the Delphi murders. Brad Holder, as you know, Judge, his son dated Abby, and Elvis Field said that, asked the question that he asked. Therefore, I think when Lieutenant Holman stated that more than one person, I only believe it's one person for a lot of reasons, one of them being that, nobody's gonna admit to it if it's just one, it bore itself out. So it's been a long day, I'm gonna sit down. I'm gonna stand on that. Thank you.
Anything else, Mr. McClelland?
Judge, just the same argument? Those are questions elicited by defense, and so they're trying to use their questions to then open the door for their third-party suspects. Any questions asked by the state were in response to the questions asked by defense, and so I believe they are trying to open the door and allow this stuff in, and so I don't think the state is proper at this point to allow that kind of evidence in, Judge.
Well, again, the case law is perfectly clear about third-party suspects, and that there has to be a nexus, and there is no nexus. There's still no nexus between the third-party suspects and the crime, so both of the motions that you have filed, Mr. Baldwin, are denied.
Thank you, Judge.
You're welcome. Will you be ready then tomorrow morning to begin promptly at 9?
Yes.
Judge, can we have a sidebar?
Yes.
As to one of the witnesses for tomorrow, so we can discuss whether some objections the state has?
Okay, sure.
Thank you, Judge.
Sidebar.
Sidebar conference conducted.
Judge, my understanding is they're gonna call Superintendent Doug Carter tomorrow.
Yes.
When I asked Mr. Baldwin before what he's gonna testify to, I don't know if I remembered everything, but anything more.
No.
The FBI?
Correct.
And I forgot the second one.
He walked on the bridge.
He walked on the bridge.
Yeah.
Was that all?
No.
Did I miss something?
Oh, the third one was, okay. I'm just gonna ask him, was there a time that the FBI was working with you? Yeah. Was there a time that you told them to no longer work with you? Yeah. And why is that? He'll say whatever. That's pretty much that. The second area is, did you walk on the bridge? Yeah. Tell me about that experience. And he actually crawled on the bridge, and I wanted that for the jury to understand how treacherous that bridge is for reasons that are related to the defense. And then the third, and that won't, those will take very quick. And then the third one is also quick, and that is, how much money did the governor, did he ever restrict the amount of money that you would have or need on the Delphi investigation? He's gonna say, no. And that's all. Mr. McClelland and I object as to relevance.
How are those relevant?
Well, the FBI issue is relevant because of this. The reason why the nexus was cut between the FBI and state police involves the loss of lost videos, surveillance video that both agencies were seeking out in the case. And so it goes to one of the themes that we've been offering up, and that is the lack of continuity of the investigation and the lack of quality.
This is the stuff that Steve Mullen testified to.
No, that was actually a different one.
Because it's the FBI, it's different. There's also, Judge, the FBI were given the extraction from Libby's phone and, to our knowledge, and based upon depositions that we've conducted, when they were gone, and there was never any, we need to be able to explain, that's part of one of our themes is, the extraction of the phone should have been done better, it could have been done better had the FBI been around. But why? But then there's this lingering question. Well, what happened to the FBI? I think the jury has the right to know that. I don't even know why it's controversial. Doug Carter kicked them out,
It's not because of we have some disagreement of how it went down.
Okay.
I just don't think it's relevant to the case against Richard Allen. Also, Doug Carter's not gonna testify to the phones. He's not gonna be able to testify to that. I don't think he's gonna be able to testify to inaudible.
Well, that's what he's testified to in the depot already, but...
So I just want to make sure I understand. You want the superintendent of the Indiana State Police to testify about the break-up with the FBI?
I think the jury just has, I don't even care about, I just want them to know that the FBI, at one point in time,
was removed.
When they left, they were no longer working together. I don't have to get into the reasons why,
And it doesn't matter.
Yeah.
You just want to get in the fact that the FBI was involved and then the
Yes.
FBI was not involved.
Yes.
We've done that already through Tony Liggett.
Tony Liggett.
Tony Liggett testified that he could call them at any time and ask them, and I think that's the truth. We could call them right now and ask them.
Well, then that would be different than what we were told by Jerry Holman about. Jerry Holman testified proudly that Doug Carter kicked them out. That's what he said. He said, yeah, I booted them out. That's what.
That's not relevant to this trial.
Well, they're going to say lack of investigation. And it's true that it did occur over lost video. And there's an email that memorializes all this, and it's very clear. In fact, when Trooper or Superintendent Carter, who was the mouthpiece for the state police throughout this entire investigation too, he acknowledged that to us in a deposition. He wasn't hiding that.
If that's the extent of that, okay. That's already in, so it's cumulative at best, so you can ask that vary, if the FBI was in and the FBI was out.
Fair. All right. That's fine. The second one was the crawling.
About the crawling?
Yes. Oh, I don't have it here. There's a photo of Abby, the 2:07 p.m. photo. Oh, let me grab it. This is the 2:07 photo that's been admitted into evidence.
Okay.
The state appears to be claiming that Richard Allen was here, although you don't see him here, and that while these girls are walking, he caught up.
Well, there's somebody right there.
There's a...
Or is that a tree?
There's a post, actually. But there.
They're walking across the bridge with them.
Right.
And you see that in the bridge video, the bridge guy video, right?
Well, you see somebody there.
You see somebody.
Yeah.
Okay.
My point is, and the point we will be making, I don't like sharing all my information with the state, but that's where I will leave it, is it's so treacherous, and Richard Allen's about Doug Carter's age, maybe a little bit younger. It's treacherous for a man to walk across there. In fact, we believe that it was somebody else at the other end.
But we have a video that shows a man, whether of bridge guy walking across there, so.
Well.
It's not that treacherous.
It was so treacherous that.
Whether Doug Carter crawled or not is irrelevant.
Well, he said it was so treacherous he felt it, that he needed to crawl.
That doesn't have anything to do with the states.
We just had Dave McCain saying he crossed the bridge. He's 70-some years old.
Well, it goes to the weight.
Why does the testimony of Doug Carter mean so much more than anyone else that's talked about crossing this bridge?
Because he's a guy that said that he crawled across the bridge, that's why. There's some people that crawl across the bridge.
It's irrelevant.
Now we're getting into that's not relevant. He can testify about the FBI, he can testify that he brought them in, he brought them out, but that he crawled across the bridge, I'm not sure how that's relevant to the guilt or innocence of Richard Allen.
I'm gonna make one, I appreciate that, Judge. I'm gonna make one last pitch. Oh, sorry. I'm gonna make one last pitch. If the state of Indiana is going to claim on closing argument and rough out the trial, as they are, that Richard Allen, who's not seen in that photo, caught up to Libby, it had to be done in a quick fashion. This is the argument that we're gonna make. Again, I'm glad that I can make these arguments to you. And
You haven't made the argument yet, but
Inaudible.
Yeah,
I didn't think that I made that 207 argument. Anyway, a grown man feeling the need to crawl when it is this is it tends to prove that what they're saying is not true. That it's so treacherous that a grown man there's a 70-year-old man, and that goes he said that he can go across that. Somebody who's lived here his whole life. Doug Carter, who has not, needed to get on his knees to crawl across there, and because he's so scared. I'm saying Richard Allen or whoever would not have been able to walk across here in such a quick fashion to the degree that Doug Carter had to crawl.
And there has been evidence and testimony presented that other witnesses have crawled or refused to go across the bridge because
was there crawling?
it's treacherous.
So that was relevant. So then this would be, too.
not from Doug Carter.
What's the problem with letting them know the truth?
The truth is already there.
The female, I think there was.
Keep your voice down.
I'm sorry. If Samibo DY could testify it was a female, not a grown man. A grown, so, I respect your ruling, that's fine. I made my record.
Yes, you have.
Thank you.
And what's the other issue?
The other one was the money.
Okay.
And that's completely inappropriate.
The what?
The money. How is that relevant?
Well, it's relevant because it was Trooper Holman said that they wouldn't move forward with the height study because it was going to cost them 10 grand. At the same time, his boss is saying that they would throw the entire state budget at this thing. I think it is relevant because I believe it goes, again, well, first of all, it's a credibility issue, and second of all, it goes to a lack of investigation. He said they were on a budget.
First of all,
I'm sorry, no.
That's a prosecutor call.
Yeah. If he said that there was money, and there wasn't, then that also just contradicts, it's contradictory. Sorry.
Again, my recollection of the testimony is that the variance of the results, as well. No W were getting into them. They came to me and they said, do you want to spend the money, and do you want to test this, knowing that there may be issues? So, if anything, I made the decision.
Okay.
So we're inaudible, B rings it up to me and I'm the one who made the decisions, and it not there's too much of a variance. It's not what it was, inaudible just like.
It's like doing voice recognition.
Well, but it's a two-part argument, and one part is that he said they didn't want to spend the money, but more important.
I didn't want to spend the money.
Well, but then.
He objected because it's not his decision to make, it's Mr. McClellan's decision to make.
He's the lead investigator.
Well, I understand that, but he doesn't make those decisions, the elected official makes those decisions, so.
Okay. So I'm sitting here thinking about, so Carter's gonna be I'm think about tomorrow like witness-wise.
Well, we're gonna try to use the list that Nick gave us
to kind of maybe do some videos.
do some work tonight.
Video.
And try to clean it up.
Are you thinking of doing those tomorrow?
That's what we're hoping to do.
All right. I'll get it done tonight.
If we want to wait,
The problem is we don't have any witnesses.
Inaudible.
Yeah, I have. I don't know that we're going to be able to mobilize people. You know where.
You gotta have something more than one witness that's gonna take 20 minutes.
Can we take a look at our list and see?
Yeah.
Let's see if you can.
Again, we're working on short notice here.
I know.
We really are.
you can maybe juggle some people around and see if you can't get anyone tomorrow.
Okay.
So I mean, because the jury shows up to work, and then you only have the one witness, and then they hold that against you guys because you won't have anybody else.
We had planned to play the video today and tomorrow, so if we play the video, that'll take up most of the time.
That'll take up some, yeah.
Yeah.
So we can do Mr. Carter, play the videos.
The camcorder video is 2 hours basically.
Okay.
I just wanted to look at that list
Okay.
and see
Oh, I do too. We haven't.
if those dates on that list match up, and can I match anything in the video. That's my intention.
I agree.
Okay.
Max seemed to think that he wasn't mad at you. He was like, this looks like it's exactly what we.
Well, that's why I inaudible.
So I'm hopeful that might expedite it.
Sidebar conference concluded.
All right. So we'll be ready, then, tomorrow morning at 9 o'clock with your witness, and potentially, maybe some of the video that we weren't able to get to today.
Yes, Your Honor. Thank you.
Okay. Perfect. All right. Is there anything else, then, that we need to discuss, or are we done?
Not that I know of.
No, Your Honor. Thank you.
Thank you.
All right. See everybody tomorrow. Jody, you can go off the record.
Off record at 5:30 p.m. On record November 2nd, 2024 at 9:14 a.m.
All right. Well, good morning, ladies and gentlemen. We are back on the record in State of Indiana versus Richard Allen, 08C01-2210, MR1. I'll show that the defendant shear in person with counsel. The state shear by the prosecutor and his deputies. We are outside the presence of the jury. And I appreciate the opportunity, Mr. McClelland, Mr. Rozzi, to have a discussion about the exhibits that you will be publishing to the jury. I believe we're talking about Defendant's Exhibit XX, it was offered yesterday. The state objected. Over their objection, I admitted it. You then had the master sheets for the movement video and the in-cell video, which we didn't get to the in-cell master sheet. All we did was the camcorder master sheet, so that'll have to be offered up at the appropriate time, Mr. Rozzi.
Would you repeat yourself, please?
Yes. The master sheet on the in-cell video you withdrew.
Okay.
So that's ZZ, and that has not been offered or admitted, but the master sheet on the camcorder has been, that's YY.
And we're going to submit an updated one.
Okay. So you've got the updated YY.
We got a new one, yeah?
Okay. So I'm gonna show it as YY1 and YY2. The updated one will be 2.
Judge, I have the updated one. I just was handed an exhibit sticker that was DDD.
Oh, okay. Thank you. Okay, DDD.
And DDD, just before that is going to be the thumb drive with the actual video.
Okay.
Which is 15 videos.
And I assume the state is maintaining its objection.
Yes, Your Honor.
Okay.
Same objection for the same reasons we had at the sidebar on November 1st for the in-cell video, if I'm following along correctly, with the camcorder video.
Right. Okay. And I know that we had a conversation in chambers about some of the content of the exhibit, that it contains some rather explicit scenes that, obviously, the jury has to see this, but I know, Mr. Rozzi, you had some concerns.
Yes, Judge. I have requested on the court, and I am requesting that we publish these videos. But out of respect for various people involved in this, including my client and his dignity, I would appreciate the court allowing us to publish these to the jurors. I think that's the more appropriate way to handle this, and I think it's just a more professional way to deal with this content.
Okay. And that's fine, I don't have a problem with that. And I know that you've moved the big screen TV to a point in the middle of the courtroom to where it's been angled so that the jury has a clear view of the exhibit, and the display is not being projected out into the audience for all of the reasons that you've just expressed. So with all of that being said, is the state ready to proceed?
Judge, just one other note before the jury comes in. Just know that the state is gonna have a continuing objection to, as we get past the first video, to then 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, the state's gonna have a continuing objection that, after we get past video 1, that any of the videos are cumulative. And so just wanted to note that objection, so the court can note that so I don't have to do that every time they move on to another video, Judge.
Okay. Thank you. And I'll just show it as a continuing objection. And if it gets to a point where, cause I know each of the videos is a specific date within the time frame that the defendant is alleging, from April to June, that we discussed at sidebar. So if I get to the point where I'm agreeing with the state, I'll ask counsel to approach, and we'll have a conversation at sidebar.
Thank you, Judge.
Judge, when you receive Exhibit E, you're gonna, obviously, the master list, the new master list, if you will. On there you'll see the length of time for each of the videos, just to the extent that that gives you some context about, about what you're seeing from a cumulative E standpoint.
Okay. Thank you.
Yeah, some of them are just 2 minutes, or
Yeah.
very short clips.
And I'm looking at the screen, and I'm seeing MPG file with 92,672 KB, whatever that is, and then others that say 479,000.
Oh, I'm sorry.
So obviously, there are different lengths.
Yeah, and they're on the master list. We've got exact lengths,
Okay.
which were on the list we got from the state yesterday.
Okay. And I appreciate the state providing that. It's work product, you didn't have to provide it, but I appreciate that you did provide it to the defense, so that they could more clearly produce this information for the jury's benefit, so I appreciate the state's cooperation on that. All right. Anything else from the state?
No, Your Honor. Thank you.
Anything from the defendant?
No, Your Honor.
All right. Let's go. Folks, could you turn your table mics on?
Sorry.
I can't see everybody on the defendant, Ms. Auger or Mr. Baldwin. Could you turn the table mics on?
Got it.
Thank you.
All rise.
Jury in at 9:24 a.m.
Thank you. You may be seated.
Okay. Everybody's all settled in over there. Good morning, ladies and gentlemen. It's nice to see you back this morning. I hope you had a pleasant evening. As we have parted company and you've had access to your phones for purposes of communicating with your family and checking work emails, I'll again ask you the series of questions that I'm sure at this point now you can recite back to me. Ladies and gentlemen of the jury, have you read, seen or heard any media accounts concerning this case?
All jurors answer in the negative.
Have you discussed this case with anyone?
All jurors response in the negative.
Have you permitted anyone to discuss this case with you?